Hi, everybody. Welcome to another Clark Tutor Legal Discussion. I'm Shashank Tiwari from NLS Bangalore, and today we're continuing with our criminal law series. We've done parts 1, 2, and 3. We've understood the basics of what is a crime, the elements of a crime. We moved on to the next stage in looking at punishment, and then we also saw some general defenses which help accused or defendants maybe claim that they didn't have intention or to prove that they did not commit a crime by not meeting one of the essential elements and thereby avoiding any liability. After seeing the general defenses, we also understood the role of the state. How is it that a crime is proved? What is the burden of proof? What is the standard of proof? Who has this burden? And then what is the role of the state? What role does it play? Who are the parties in a criminal battle? Who is the person representing society at large? And we've understood all of the basics that we needed to. And now we come to the more complicated question of jurisdiction. Jurisdiction in itself means the extent or what the permission or the powers are of any particular entity, organization, law, or maybe even some body. So the jurisdiction of the Indian constitution expands to all of like in the Indian territory and also Indian citizens. Similarly, the jurisdiction of, let's say, the Karnataka police is limited to Karnataka. So as you can understand, jurisdiction is the extent of power or the limits of how much some application of law is to happen. Now, the jurisdiction of the Indian Penal Code, which is one of the fundamental basics of crime of the criminal law in India, jurisdiction as per the IPC can be seen very carefully from section 3 and section 4. Now, this might be a little complicated, but if you listen to me carefully, you will get an understanding of what is going on, and you will relate when you can think of, recent cases in the real world that do happen. Section 4 of the IPC says that the provisions of the code apply to any offense committed by. Now, there's two things to notice here. The provisions of this code, which means the Indian Penal Code applies to any offenses committed by. IPC as a legal, statute as law is applicable to the commission of the acts, the person committing the act, which means the accused or the defendant. You have to look at the actions of the accused, of the person committing the act to understand jurisdiction as per the IPC. It's not about the victim. It's not about the person who is, a victim of this crime, but it's the person committing the crime. From that perspective, the IPC applies. The jurisdiction is seen from the side of the person committing the act. So the first point in section 4 says that any citizen of India in any place without and beyond India. And I want you to read this from the section 4 sentence itself. Any offense committed by any citizen of India in any place without and beyond India. So any Indian citizen, no matter where they are, if they commit a crime, then they are liable under the IPC. They can be tried as per the provisions of the Indian Penal Code. Once again, I repeat, Indian citizens, no matter where they are all subject to the Indian Penal Code. Point 2, again, we will read with the section itself. The provisions of the code apply to any offense committed by any person on any ship or aircraft registered in India, wherever it may be. Now, this is what we call the floating island principle. And what this means is if there is an Indian ship, an Indian plane, which means any ship or plane registered in India or carrying the Indian flag, then that ship, plane, or any vehicle for that matter is seen as Indian territory. An Indian ship carrying the Indian flag, let's say in the Pacific Ocean, is considered Indian territory. So if any person is on that ship or any person on such a floating island is committing an act or an offense, then it's seen under the purview of the Indian Penal Code. The third point, again, we read with the section, any offense committed by any persons in any place without and beyond India committing offense targeting a computer resource located in India. Now, the IPC is from 1860, and obviously computer resources weren't a cause of concern back then. So you know that this is an amendment. This is a change that has been made. And the change is to say that if any computer resource, any computer, phone, laptop, network is hacked or let's say targeted, which is in India, then the offense can be tried under the Indian Penal Code. And this is important because cyber crimes are a very, recent form of criminal it's a recent branch of criminal law, and we have to make changes to adapt to cover those. And the Indian Penal Code, with this amendment, has made that change. There are also other provisions, such as the IT Act, but the Indian Penal Code makes it clear that jurisdiction of the IPC will extend to all and any attacks against Indian computers or computer resources located in India. Now, one example which might help us understand things is Section 3. What it states is that if a person, now this isn't the exact stating of Section 3, what I've put here, but Section 3 is a little complicated when you read, which is why I've explained Section 3 through an example. And what it would mean is that if an Indian citizen commits a crime in Canada, and he can be tried in the same manner if such an act had been committed within India. So if the person is Indian and he's committing a crime in New York City or Hong Kong or Quebec, Canada, or maybe, Newcastle, the point is that they will be seen as having committed the crime in India. The IPC will not differentiate where the crime has been committed, whether that is in Mumbai or, London. The fact is that an Indian citizen has committed the crime. So the IPC will look at both instances similarly. That's the extent of jurisdiction. That's how we understand how the IPC applies. And especially when we get passages about Indian citizens doing things abroad or Indian citizens being victim abroad, these are the situations we will look at. Jurisdiction from the IPC in section 3 and 4 will be relevant to us. Let's also briefly look at procedure when we're looking at jurisdiction. Now, I mentioned in previous classes that the Criminal Procedure Code of 1973 establishes the processes and the powers of the different mechanisms in the criminal justice system. The police, the courts, all of those are bound by the CRPC because they follow the Criminal Procedure Code. And the police, the court, the public prosecutor, and defense counsel, these are some of the 4 pillars or key institutions within the criminal justice system. And all of them are bound by the CRPC. Now, for the CRPC, there are some guiding principles. You'll often see new judgments, legal cases, updates from maybe bar and bench, live law, or those updates which we share with you on the group. Criminal procedures often discussed. It's a very controversial topic. There are very fast-paced, changes, updates that are coming from courts. But the fundamental principles of CRPC must be followed. And those are the bullet points here, which are fairness, justice, presumption of innocence. These fundamentals will never change and they should never change. If there are judgments or situations which go against these fundamentals, then courts will come out with new judgments, with new cases that will counter those and bring it back to the general principles because these guide the CRPC. Now, there are other, procedural codes. There are other specific crimes. There is the Prevention of, Sexual Harassment at Workplaces Act. There are other acts like the POCSO. There's also other acts like the UAPA and the TADA, which have their specific procedures. They have different, processes. The guiding principles are the same. They are very similar to the CRPC, and even in those procedures, the CRPC mentions in its statutes that specific crimes that have different procedures, those will be followed. Because in some cases, let's say terrorism, the procedure needs to be a little more, secure, a little more complex, a little more different, because the crime, it's so much more different, is so much more complex. And we discussed this in one of our first classes. The simpler the crime, the simpler the punishment, and simpler the procedure. Similarly, the more complex the crime, the more complex the procedure. That for us is our basic understanding of criminal procedure, seeing what other criminal procedures apart from the CRPC rely upon, the guiding principles, and some of the key institutional frameworks of the criminal justice system. We've also just discussed jurisdiction, which is another topic that's important for us. But this in whole covers our criminal law module. We've discussed this in 4 parts, and I hope everything has been clear. You don't have to worry about the specifics if you don't remember sections and if you don't understand the complexities. Getting a basic idea for us helps a lot during our CLAT exam because the passages that are specifically on criminal law, they become easier to understand, faster to read, and help us get a better, grasp of what the questions might ask. But that's all for criminal law. That's all from my end on these 4 parts. Thank you from CladTutor. If you have any questions, any queries, please feel free to mail us at hello@cladtutor.com, and do give us your feedback in the comment section. I hope these 4 parts have helped. And until the next time, please stay safe, take care, and I shall see you. Thank you and goodbye.